And now, Legal Perspective with Nick Clekis.
In the challenging world of workers' compensation, several issues might lead you to seek resolution through a hearing. We're happy to welcome back Jackie Drescher, attorney with Clekis Law Firm. Jackie, great to have you back with us.
Thank you.
And can you speak to some of the common reasons why someone would file for a hearing?
Well, there are a number of reasons. The first reason would be if your claim is denied, completely denied, then you're going to have no alternative other than to file for a hearing. If the employer hasn't even reported the claim, then you're also going to need to file for a hearing to get the benefits you deserve, the medical treatment, the time and money that you've lost from work, mileage to and from the doctor, et cetera. So at the end of a case, you would file for a hearing if you can't agree on the amount or value of the claim, and that is a different type of thing because that would end the claim. But there are hearings that are done that don't end the claim, that are just for more medical care or because you're not getting your wages.
Okay, so filing for a hearing is pretty much, you're in disagreement with how it's being played out at the moment, right? So what does the hearing process look like from start to finish?
Well, the moving party will file generally a Form 50 request for a hearing, and I say generally because there's a Form 52 if the person has died on the job. But a Form 50 if there's an injury on the job is what the claimant's attorney would file, and then the defense will file a response to that. Once the case is set for hearing, the moving party would file a brief. It's a Form 58. They have a lot of forms in workers' comp, but file the Form 58, and you have to list all your witnesses. You have to attach the medical records that you intend to use, and that sort of thing, which is great because they don't require the doctor to appear and testify in person. The commissioners read the medical records, and the defense would do the same thing and present their evidence. And then once you go to the hearing, the date is set, everybody arrives. There's usually a pretrial meeting between the commissioner and the attorneys, and then the hearing would start. And we put up our witnesses just like you see in court. We have them testify as to everything they've been through or anything pertinent if they're not getting their medical care. We point to the records if there's something in there that says we referred him for MRI and it's their approved doctor if they're not approving that. We argue that's what needs to get done. And sometimes filing for a hearing gets the matter resolved before the hearing actually occurs. They have to, the insurance company will hire a defense counsel, and the defense counsel will review it. And if they see the issue and realize that something should be done, they'll sometimes get it done after we file for that hearing before the hearing date.
How long is this process typically? This sounds like there's so many different moving parts involved.
It's different on different cases, and I've had some that have gone on for years because, first of all, it hinges a lot on the claimant treating. If a claimant is treating for a long time, say years, then the case is going to go on that long, unless they are released at maximum medical improvement with future medicals indicated. Then you can resolve the claim, leaving medicals open, or allow value for those medicals, and sometimes do that in the form of a set aside. If especially you could do a Medicare set aside because you have to take their interest into account and set aside some money for the future medical care if that's recommended.
Jackie, speaking with you has really just showed me even more so how important it would be to get an attorney involved if you're seeking workers' compensation. How can we get in touch with you and Clekis Law Firm?
Well, we have two locations to serve you, 2850 Ashley Phosphate, North Charleston, and 171 Church Street, downtown Charleston. My line downtown, 843-225-5253. Or you can call our main line, 843-9000000. It's easy to remember, and you'll always get a person to talk to.
Easy to remember, yes. 843-9000000. Jackie, thank you so much for being here with us today.
Thank you. Bye-bye.
We're back in 2 minutes.
This has been Legal Perspective with Nick Clekis.